Many thanks for rejoining us again. And the program is Good Morning Abuja, showing only on the Unity Station NTA Channel 5 Abuja. And on to our very first conversation this morning. We want to talk about something that will interest you. It concerns you and I. We want to talk about speedy administration of justice in the Federal Capital Territory. And we have a legal practitioner with us this morning. Help us welcome Yahaya Issa Akot to the program. Barista, you're welcome to the program.
Thank you, madam. It's a pleasure.
All right.
You are welcome.
Okay. Speedy administration of justice in the FCT. Now, as a lawyer, sir, the attainment of justice represents one of the enduring promises of constitutional democracy. In your view, we want you to react to that.
Yeah, thank you, madam, and thank you, viewers, once again. When you talk about speedy administration of justice, in fact, justice itself, to a legal practitioner, is not a one-way traffic. Every human being, every society desires justice. Justice is not only meant for the accused, as the case may be, nor is it meant for the prosecutor, as the case may be. It's meant for the larger society. And so there's this popular cliche, justice delay is justice denied. So there's no gainsaying in the speedy administration of justice. And what that means is that for even a prosecutor, as well as even the accused, the duration, the time lag between when a matter is commenced and when the matter is determined matters so much.
Yes.
Because a lot of resources is going into that endeavor. And for that reason, the earlier the man that is standing in trial knows his fate, the better. The earlier, too, the justices dispense with the toga of justice is better for all of us. And the earlier, too, the practitioner discharges his or her obligation at the bar is better for all of us. And so the period within which this is realizable or within which this is discharged is very, very key. And that is why there is no gainsaying, as I earlier said, that administration of justice must be done timely. Thank you very much, madam.
Talking about timely administration of justice, we know we have cases here and there, but it's not for us to go into them. But we are here to look at the way forward. You know, we have so many people, let me say, that rot in jail at the moment because of this delay. Going forward, in your opinion, what should we do?
Of course, when you talk about people rotting in jail, you are talking maybe those who are standing trial or awaiting trial, as the case may be, or those who have been adjudged to be guilty and they are serving their jail term. So you must divorce these issues. However, let me pick on one. For those who are awaiting trial, the period within which they should be there should be reasonable. Of course, for an offense, for example, where if an accused is eventually convicted of the crime, and the penalty for which may be 3 years, and this person is standing trial for 6 years, you will know that, yes, you don't need to be a lawyer, you don't need to be a judge to know that something is wrong in that system.
Okay.
Because the ultimate upon conviction is 3 years, and trial is spanning for 6 years. You will ask yourself, what are we doing? What type of system is that? Although our administrative justice system here is not inquisitorial, it is adversary. What I mean is, we don't have a system of we don't have a jury system here. So for every matter, you as a lawyer must prove your case beyond reasonable doubt or on the balance of probability, depending on which side, whether it is civil or criminal matter. But in this matter, for those who are maybe the accused or the appellant, as the case may be, it is in the interest of justice that the period within which the trial is commenced and the matter is determined shouldn't be more than the period within which the consequence will be served. Okay. And so all hands must be on deck to ensure that there's a breach of time, because we can do that. I believe we can do that.
Possible.
It's possible, madam, because it doesn't do anybody any good. Even it burden the society, it burden the country, it burden the nation, because of maintaining an inmate, all right, feeding an inmate, taking care of an inmate for an offense of 3 years, but he's standing trial for 6 years, is ridiculous. Very, very ridiculous. And there's no sane society where such a practice is tolerated. So I think we can make amend, and we can bring sanity to our own judicial system as well. Thank you very much.
We can make amend indeed. Now let's talk about the impact of recent appointments of 12 new judges in the Federal High Court in the FCT. You want to talk to us about that?
Yeah, madam, this gesture is very, very applauding.
Okay.
Yeah, it's a right step in the right direction. Because if you put in context the entire framework of the burden of work done by the people that man our bench is very enormous. The judges are going through a lot. It's not easy to be a judge, although that is their calling. So between the bar and the bench is a symbiotic relationship. So there's nobody that is on the bench that was one time not at the bar. You get what I mean?
Yes.
So you must evolve from the bar to the bench. So the experience of those on the bench is not a light experience. And the work that they charge there is Herculean, is enormous. And where you have the number of justices or judges, as the case may be now, the burden of work or the load of job that they do is going to now be lessened because of the new enroll, the new intake. So now, where ordinarily files are to be assigned to a particular court will now be distributed among these 12 that are coming new on board. Because if you go to our system, it's burdened with a lot of cases.
Yes.
The judges, madam, I must tell you, I applaud them. It's not an easy job. So this appointment, for me, as I said, is a right step in the right direction.
Okay.
Thank you.
All right, that's a very good one. And quickly, because we do not have much time, you really talk to us about the speedy administration of justice, especially in the Federal Capital Territory. We want you to talk to us, rounding up and in form of advice, the way forward.
Yeah, madam, talking about the way forward in the administration of justice, I want to borrow a theory from a development theorist who talk about structural functionalism. I think it was populated by Emily Durkheim, and in that structural functionalism, he sees the society as a structure of different components or different units, and they function together for the common good of that society. So every department, every strata, every facet is very important. And so those in the judiciary, they are not less important than those who are not in the judiciary. Because if you see society in that route, if you see society in that prison, you begin to appreciate that you do your bit, I do my bit, and the society will be better for all of us. And so the burden of social engineering, as the case may be, which the law seeks to entrench, that burden will become very attractive, become very productive when all the strata of that society begin to take the mantle or begin to function in that regard. Bearing in mind that if you fail to do your own obligation, yes, it's going to tell negatively on the other component of this structure. So we are in for it. We must salvage it together, we must synergize together, and we must deliver it together. Yes. Thank you.
Thank you very much for your time with us this morning. We do really appreciate it.
Thank you, madam. Okay. It's a pleasure.
Yes, we've been talking about speedy administration of justice in the Federal Capital Territory with a legal practitioner, Yahaya Issa Ako, and he has told us what we need to know this morning. Indeed, justice delayed is actually denied. So So let's put a speedy activity and action into it to ensure we have a safe generation and a society to live in. The program is Good Morning Abuja. Let's go on this quick break. When we come back, we have more for you. Stay with us, please.